Okay, this video is going to take a bit of a deep dive, so grab a coffee and listen up. Bear with me through the difficult bits. The Treaty Principles Bill hearings before the Justice Select Committee wound up at the end of January. I've had more than a few questions about my own submission, which I thought was unique. However, one of the latest submitters was retired District Court Judge and practicing barrister David Harvey. Judge Harvey's oral submission was limited to 10 minutes, but in that time, in a roundabout way, he asserted the substance of the argument that I made in my submission. This argument is one that I partly covered in a video back in November last year. We'll get to that shortly. Judge Harvey's submission covered much of the ground that mine did. If I put both our submissions together, I can state the argument in the following terms. The Treaty of Waitangi cannot be interpreted in a manner which impliedly repeals the protection of the rule of law promised in and founded by the treaty. It follows that the treaty cannot be interpreted so as to defeat the principle of equal rights, upon which Magna Carta and the 1688 Bill of Rights and many other domestic human rights laws are founded. To do so would be to impliedly repeal them. I go further than Judge Harvey. I argue that the Treaty of Waitangi is not the source of the promised protection of rights guaranteed in the Treaty of Waitangi. Rather, the operative protection is manifested in the rule of law. This means that it is the corpus of law, including cornerstone statutes such as Magna Carta, and not the Treaty of Waitangi, from where the protection of treaty subjects' rights are derived, and that law is premised on equal rights for all subjects within the realm. Let's watch how Judge Harvey puts this.
If we look at Principle 1, we have the power to govern New Zealand in the best interests of everyone. This incorporates the principle that the Crown has the right to govern. Edmund Burke considered that society is an enterprise that promotes the interests of all parties, and that partnership depends upon respecting those interests. The government, therefore, is a partnership between the people and the state, and thus the principle of partnership is necessarily preserved. As part of a partnership principle, there are a number of collateral elements. The active protection principle is inextricably linked to that of partnership. Given that Māori are a constituent part of everyone, the active protection principle ensures the protection of their interest. Implicit in any partnership is the principle of good faith dealing. If a government excludes good faith, it loses legitimacy and will fail. When there is a breakdown in a partnership relationship and wrongful acts are done by one partner to another, there is a right to recompense and adjustment, and thus that principle is present. The recompense principle is also recognised and given effect in Principle 2 of the Bill. Thus, in my argument, the existing principles of partnership, active protection, equity and fair dealing, and remedies for wrongs are included in Principles 1 and 2 of the Bill.
One of the things Judge Harvey's submission highlights to me is the appalling quality of judicial appointments in New Zealand. I'm not talking at all about Judge Harvey. I support his submission, but I cannot imagine a valid argument to support the idea that even a lawyer, let alone a judge, and Supreme Court judges at that, cannot or do not use counterfactual reasoning. Let's just consider what they held again. If you hold, as they did, that the Crown and treaty subjects must act reasonably and in good faith towards each other, the counterfactual inference is that the Crown can act unreasonably and in bad faith towards sovereign subjects. If you hold, as they did, that the Crown has an active duty to protect the rights of treaty subjects, the counterfactual inference is that the Crown can neglect and breach the rights of sovereign subjects. If you hold, as they did, that the Crown must consult with treaty subjects and balance their rights to personal autonomy, the counterfactual inference is that the Crown does not have to take into account the views of sovereign subjects or balance their rights to personal autonomy. The public service and a good deal of other misguided individuals and organisations have taken these inferences to mean that it is appropriate to single out treaty subjects for preferential treatment in regard to what are in fact under the law the equal rights of all subjects. The application of these principles are where we find ourselves questioning whether we have equal rights as New Zealanders, or whether some New Zealanders are more equal than others. It's not so much the idea that treaty subjects have special rights, it's the idea that the Anglo-Saxon own Crown has ostensibly demoted its sovereign subjects as second-class citizens. When you think about the statement from the judiciary that the Anglo-Saxon's own crown is protecting fewer rights of its sovereign subjects than its treaty subjects, you understand just how much we need to do something about the ideologically infected narcissists that pass themselves off as jurists and hijack our legal system. What Judge Harvey argues for technically is, if I understand him correctly, that the protection of rights in the Treaty of Waitangi is coextensive with the protection of rights under New Zealand domestic law. I agree with that conclusion, but I think if you take the legal principle of treaty duality into account, there's a little more to it than that. I think the correct view is that the treaty promises the protection of rights, but does not directly protect them. That's plainly what the treaty says in any language. The treaty promises to deliver the protection of the rule of law, but the treaty is not the rule of law in and of itself. A promise of a police force is not a police force. The orthodox principle of treaty duality followed by New Zealand is that the treaty is not actionable and therefore protects nothing. This opinion is also consistent with the true position that the treaty is a founding document and is spent. Again, the judicial activist neo-Marxists try to maintain the incoherent dichotomy that the treaty is both a founding document and a living document. Next to shared exclusivity, that has to be the most classic example of judicial masturbation, since they removed our right to appeal their madness to the UK Privy Council. Founding a colony in law is a singular event, not a continuum. The treaty is legally spent and cannot be a living document. Let's roll the clock back to November last year and see how I explained this in an earlier video. The judiciary has not understood that the Treaty of Waitangi to descendants of natives isn't anything more than what Magna Carta and the 1688 Bill of Rights is to Anglo-Saxons. The Crown owes all its subjects its special protection and a relationship based on good faith. And this has been the rule since the ancient English feudal system, when military service was the price the subject paid for the protection of the king. The fact that the Treaty of Waitangi explicitly sets out the orthodox relationship that the Crown has with all its New Zealand subjects does not mean that the substance of the relationship is in any way different for descendants of natives compared to Anglo-Saxons or others within the sovereign realm. It is, after all, the crown of the Anglo-Saxon people. The Treaty of Waitangi cannot amount to a treaty that enacts over territory the force of Magna Carta and the 1688 Bill of Rights, and at the same time permit two classes of people, relegating the Anglo-Saxons to second-class citizens. Magna Carta and the 1688 Bill of Rights do not allow for that circumstance, and if our jurists were worth half their salt, they would comprehend that. Now, what's interesting in this analysis of the treaty is that the Treaty Principles Bill is simply reasserting the principles of Magna Carta and other constitutional enactments as a gloss over the interpretation of the treaty. If you were to take New Zealand's first approach and have no principles at all, and properly consider the treaty to be spent, and by the grace of God repeal the Treaty of Waitangi Act and burn down the ethno-Marxist tribunal, then the position of the ACT Party and the position of New Zealand First have exactly the same effect. The only difference between them is the way in which the effect is achieved. ACT wants to have principles that disallow inequality, whereas New Zealand First wants to remove existing principles that allow inequality. ACT wants to layer the bullshit with more bullshit. New Zealand First wants to just remove all the layers of bullshit. Either pathway leads straight back to Magna Carta and domestic law. On this approach, we can also see how everything went so wrong by dealing with claims from treaty subjects as purported breaches of treaty-protected rights, instead of properly treating them as purported breaches of domestic law-protected rights. What the Waitangi Tribunal and the judiciary have done is to give the treaty the status of a protector of rights, rather than its correct status as a promise of protection. By deriving the protection of rights from the treaty instead of domestic law, the judiciary has positioned itself to have two menus of rights to choose from instead of one. On one menu you have New Zealanders' rights for which everyone has protection, and on the other menu you have more New Zealanders' rights which only apply to treaty subjects. The dynamic that's worth noting in all this is the Fisheries case. This is a good example to explain the legal framework I've just discussed. Under British common law, there is provision for native customary rights. These are the fishing rights in question. These are not treaty rights. Any native in any part of the British Empire has these rights under the British common law. One of the elements of customary rights is exclusive use. Under British common law, exclusive use means sole and undisturbed possession. But the court used treaty subjects tikanga to bypass the common law and introduce a thing it says is shared exclusivity. This has defeated the British common law insofar as it allows for customary fishing rights without the necessary sole and undisturbed possession. And this legal rule only applies to treaty subjects, therefore amounts to illegal discrimination. I hope that explanation has not baffled anyone. I've done my best to keep it clear and highlight the really important parts of Judge Harvey's submission. Should treaty subjects have different rights to sovereign subjects? Who's got the best approach, Act or New Zealand first? Please do leave me a comment and let me know what you think. Thanks for watching. Give us a like, would you, and do click subscribe to be notified of new content as it drops. See you next time.